My name is Lori Dahlberg, and I am an HR consulting manager here at Eide and am responsible for assisting our clients with different HR matters. I've been with the firm for 17 years in January and have been in a number of different roles here, but have really enjoyed this HR consulting role, which has allowed me to work with clients. And one of the things that I have done quite a bit of in the last year or so is I-9 audits. So that is what has us talking today. I will say that I don't think anyone can be an expert in the I-9. Any topic that requires a government-issued 65-page manual for a 2-page form kind of has some complexities to it. But what I want to do today is just provide you with some basic tips and tools so that you can move forward and successfully complete this federally required form. So we're going to talk about I-9 basics, but before we jump into that, I just want to talk about the history of the I-9. For starters, it was enacted by the Immigration Reform Act in November of 1986. And basically what it's doing is it's requiring employers to verify the identity and the employment eligibility of employees. It's really designed to make sure that employers out there in the United States are hiring individuals who are legally authorized to work in the United States. It also created criminal sanctions and civil sanctions for any violations of that act. And it designated the Employment Eligibility Verification Form, I-9, as the means of documenting the verification. Now, compliance with the I-9 is enforced by the U.S. Immigration and Customs Enforcement, or ICE agency. And as you have probably seen in the news, or maybe you've experienced yourself, ICE is doing a lot to audit, especially in particular industries where traditionally illegal aliens have been employed by individuals unlawfully. And they are trying to crack down on that to make sure that employers truly are enforcing this regulation to ensure companies employ individuals who are lawfully acknowledged to work in the United States. So if ICE decides to conduct an inspection, what will happen is they will send a notice of inspection to an employer. They will then inspect your I-9 forms, and they'll give you a notice of suspect documents or any notice of discrepancies. They will then determine violations. If there are no violations, they will indicate that you are compliant and your ICE audit is over. If there are violations, they will determine if they're technical violations, things that can be corrected on the I-9 form. They aren't necessarily, they're not saying that you're hiring individuals illegally. What they're saying is that the form isn't really completed properly and that you may have to go do some groundwork to prove the work authorization of someone who's filled out a form. They also are looking for substantive violations. And what that means is they are looking for patterns showing that an employer is not following the proper process and actually is hiring individuals who are not legally authorized to work in the United States. With those types of violations, you can get a warning notice where you need to clean up your act, or you may get a notice of intent to fine. And those fines could require you to go to court and could result in some significant penalties. For penalties, ICE considers 5 factors when determining what those amounts will be. Number 1 is the size of the business. The bigger the corporation, the more issues an employer might have with their I-9, the larger the penalty may be. They also look to see if there was a good faith effort to comply. That means that if an employer has demonstrated that they've made corrections to I-9s that they saw may have been incorrect, or if they see that the employer truly is trying to fill it out correctly, but may be making one of those technical violations, then they consider that to be a good faith effort to comply. They also look at the seriousness of the violation. Is it a violation where the employer is hiring individuals who are not legally authorized and continue to do so? If that's the case, then they are probably going to impart some pretty hefty penalties. They also look at whether the violation involved unauthorized workers, if no I-9 was found, and they look at a history of previous violations. The penalties can range anywhere from $573 to $20,130 per occurrence. And it's going to depend upon the number of violations that they find divided by the number of I-9s where there was an issue. And with that in mind, if it comes up that 0 to 9% of the I-9s have violations, then the fine will be somewhere between $573 for one of those technical violations on up to $6,878 for a substantive violation. And as you see, if the percentage of incorrect or I-9s that are not done properly gets to be 50% or more, then those fines can be $3,898 per violation on up to that $20,130 per violation. So those fines can be enhanced or mitigated based on the severity of the violation and or repeated violations. So if you're keeping good documentation, if you're filling out your forms properly, the fines will be much smaller. But if you are indeed hiring individuals without proper work authorization, you are at risk to pay some pretty hefty fines. And the first polling question is, have you been audited by Immigration and Customs Enforcement? I'm curious to know if anyone on the call has had an ICE audit. Oh, that's excellent. I am happy to see that no one has been audited. And I will send positive vibes and positive thoughts your way that trend continues. All right, so we're going to talk now about completing the I-9. With the I-9, proper completion is extremely important. And a majority of the technical violations that are found because employers or new employees rush through the form, don't pay attention to what it is that they're filling out, and don't complete all of the sections. So it really is important for you and the employee to take your time when filling out this form, to review every single detail and make sure that you are entering information in every section and that you are doing so with the appropriate information being requested. So we're going to walk through the different sections of the I-9. The first thing you want to do is you want to provide any new hire or employee with the instructions for filling out the I-9 and the list of acceptable documents, which are found on page 3 of the form I-9. So when you have a new hire, as part of your onboarding package or any communication that you share with that employee regarding orientation or what to bring or what to expect on their first day, you should include page 3 of the form I-9. And the reason you want to do that is because this is telling them which documentation they need to bring in order to confirm that they have the legal right to work in the United States. Many of the forms that are required are ones that people have at home or may have in their purse or their wallet, but some of the forms may not be something that they have in their possession. I'm thinking of students, let's say interns who are starting with you and they have to fill out a form I-9. They may not have their social security card or their birth certificate or their passport. They may have that at their parents' house. And so providing them with enough time to reach out to their parents to get those original documents so that they can complete their I-9 form and you can confirm and validate those documents is really important. Because as you all know, the I-9 form has a time-sensitive deadline with regards to when you have it completed. So with the acceptable documents, the thing to keep in mind is that an employee has to provide either one item from list A, or they have to bring one item from list B and an item from list C. All right, so be sure to share that document with them ahead of time so they can get appropriate documentation and bring it with them on their first day. So with regards to Section 1 is the employee attestation. That is the section that an employee has to complete, and they must complete that section either on their first day of employment, and the first day of employment is the date that they actually will start to receive wages or other form of compensation for being in your employment, right? So if you do orientation that first day, that they are going to get paid for, they have to fill out the form by that day. You can send them the I-9 form so that they can complete their section before their first day of hire, but it has to be after you've offered them a job and they have accepted it. That is the only time that you can forward the form I-9 onto them for completion. So let's take a look at Section 1. And I have pointed out with arrows the different areas where we tend to see some of those technical violations. The first section, Section 1, Employee Information and Attestation, this is the section employees complete. They need to put their last name in the last name box. And if they have two last names, or if they have a hyphenated last name, both last names or the hyphenated last name go in that box. In the first name, they'll put their first name, and their middle initial, if they do not have one, they will put NA. Same with other last names used. If they do not have a middle initial, they have to put NA. Every box has to be completed. For the address, usually employees get that one pretty correct. So they just put in their street address. If they don't have an apartment number, they should put NA in that box. City or town, state, and zip code are usually pretty self-explanatory. But employees tend to mess up on the date of birth for some strange reason. A lot of times they'll put their hire date there, or they will spell out the words. It clearly states that it needs to be in a 2-digit month, 2-digit day, and 4-digit year. That is how the employee needs to enter their birth date. Their social security number, I've also seen some employees transpose numbers from their social security number. So if they are providing a social security number as a form of documentation, then you will want to make sure that they have entered their social security number the same as it appears on their card. If an employee wants to include the email address or the telephone number, they can do so. If they do not, they need to put NA for not applicable in both of those boxes. Next, we come down to the section where the employee is supposed to indicate what their citizenship status is. And I have seen a lot of citizens of the United States check the lawful permanent resident box because they believe they are a lawful permanent resident of the United States. But the fact of the matter is, a lawful permanent resident will have an alien registration number or a US CIS number. So if someone checks that lawful permanent resident box and they have not indicated what their alien registration or US CIS number are, then you should ask them, are you an alien, a legal alien here? Or were you born in the United States, or have you been made a citizen of the United States? Just to confirm, because you want to make sure they check the right box. Down at the bottom, one of the second biggest technical violations that I often see is that employees fail to sign the Section 1 area down there where it says signature of employee, and the date that they sign it has to be done, again, in the 2-digit month, 2-digit day, and 4-digit year. With that, I also see employees putting their birth date or some other date. It needs to be on the first day of employment, or it can be prior to their first day of employment after they have accepted an offer. If that date is beyond their first day, you need to attach some documentation as to why they did not complete it on their first day. In Section 1, there is also a preparer and/or translator section, and this section is found at the bottom of page 1. I oftentimes see that employees do not check a box indicating that they did not need to use a preparer or translator in those circumstances where they fill out the form themselves, or check if they did have a preparer. Employees have to indicate whether they had a preparer or translator assist them with completing it. And it is completely legal for someone to assist another individual with completing this form. So the thing is that if someone did assist them, whether they helped them fill it out, physically fill it out, or if they translated it so that the employee could complete the form, that's fine. They just need to indicate that yes, they had someone assist them with it, and that person needs, the person who prepared it and or translated it needs to sign it, date it on the day that they helped the employee fill it out, which again should be by their first day of employment. And then they need to write out their specific information with regards to their last name, first name, and address. Section 2 is where the employer does their part. And it is really, really important that employers understand they are legally required to complete the Form I-9 within 3 business days of the date employment begins. So if orientation happens on the first day, that is when the I-9 form should be completed by the employee. And truthfully, that is when the employer should be verifying the documents, because they have to physically examine each original document that the employee presents to determine if it is genuine and if it relates to the person presenting it. We cannot just accept a photocopy of documentation, hand it off to the HR person along with the I-9 form so that they can verify it later. The person who is signing off on Section 2 has to physically be there to examine the documents and to check and make sure that the photo ID matches the new employee who is filling out the Form I-9. Which gets to the third bullet point. It has to be the same person who reviews the documents and then signs Section 2. And you can designate somebody. So for example, if the HR department is in one city and the new hire happens to be at a location in another city, if there is a designated person in that office who does orientation, that person can be the individual who does the employer portion of the I-9. But you just have to make sure that it is a designated individual or designated individuals. And to be truthful, it's best to have one person who knows exactly what they're doing with regards to completing the Form I-9 than it is to think that everybody knows how to do it properly. So having primary contacts in various locations can be really helpful for that. The employee must be physically present with the document examiner, and the employer cannot specify which documents an employee must present. This gets back to that whole tip that I provided earlier about sending that list of acceptable documents to a new hire once you've determined when they're going to start, so that they can determine which items they are going to bring in. You cannot even tell them, oh, you need to bring one item from list A, such as a passport, or an item from list B, like a driver's license, and an item from list C, like a social security card. You cannot even do that. You just need to provide them with the list and tell them one item from list A, or an item from list B and an item from list C, and that new hire has to determine which documents they want to bring. Another really important thing to keep in mind is that if an employer chooses to make copies of those work authorization documents, they have to do so for all employees. And you should photocopy the front and the back of the documents that are presented. Oftentimes, there is information that is on the back of a document that actually includes important information with regards to who the issuing authority is or what the actual document number is. So you want to make sure you have copies of both the front and the back. If you do not make copies of work authorization documents for employees who are completing their Form I-9, that's perfectly fine. You just have to make sure that you are consistent with that practice. And one of the only benefits of keeping copies is that if you notice that something has been completed incorrectly because you have a copy of it, you can make that correction. If you don't have those copies, you won't be able to make the correction. But if you, on the flip side of that, if you retain copies, and an error has been made and you don't catch it, then you're liable for that. So this is section 2. Section 2 is the second page of the I-9. And again, I've placed arrows at some of the spots where we find more of the technical violations. The most common error I find in all I-9s is at the very top of section 2, where it says employee info from section 1. I see this section left blank about 85% of the time because people just gloss right over it and get to putting in the information regarding the documentation. You have to enter their last name as it appeared on page 1, written out by the employee or their translator. You have to include the first name, that middle initial. Again, if they don't have a middle initial, you'll just put NA for not acceptable. And then the citizenship or immigration status. This is the number of the immigration status that they checked. Number 1 would be for a citizen of the United States. And remember, number 3 was that alien registration card, that you would put a number 3 in there if that is the citizenship status. So it's one of those numbers that appeared in the citizenship status box from page 1. In this example, the individual has provided one item from list A. A U.S. passport is a list A item. And as you can see, the document title, they have put U.S. passport. You need to make sure whatever you put in this section is the actual name of the document. You cannot assume that you're just going to put passport because you're in the United States and that's the only passport that can be provided for documentation, because that may not necessarily be the case. So you have to draw out that it is a U.S. passport. The issuing authority is not the United States, which I see a lot. It is the Department of State. And there may actually be another issuing authority. So you want to make sure that you look on the document for who the issuing authority is. You want to take care when you write in the document number to make sure that you don't transpose any numbers or letters. Just enter the document number exactly the way that it should be. And then for the expiration date, look on the document. They have so many dates on there. They'll have an issuing date. They might have a birth date. They may have some other date on there. You are looking for the expiration date. And the expiration date, again, needs to be in a 2-digit month, 2-digit day, and 4-digit year. A lot of technical violations happen when individuals are using List B and List C items. In that, oftentimes people will put a List B item information in List C and put the List C information in List B. And that will get you a technical violation penalty. So make sure that you know which items are supposed to go in List B, and if somebody provides you with one of those items, record it properly, filling out again the document title, the issuing authority, the document number, and the expiration date. On the List C side of things, there are many List C items that do not have expiration dates. And if that is the case, then you will put NA. And 2 examples that I can think of that are used quite frequently are Social Security cards and birth certificates. So if someone is using a document that does not have an expiration date, put NA for not applicable in that section. Another thing to keep in mind is that there has to be some sort of photo ID. Most of the items in the List A category have a photo on the document. The same applies with List B items. So if you are using a List C item that doesn't have a photo, you want to make sure that the List B item does have a photo. The additional information section is a section that employers can utilize to enter just general information that they may find. A lot of times, additional information might include, if there was a receipt given, like a document receipt, which we'll get to here soon. If somebody is using the receipt as documentation, so a receipt for a Social Security card, for example, because they lost theirs, then you could put in their receipt for Social Security card, utilized and then put the date, and then when they actually turn in the original copy of the original of their social security card, you can write those notes in there. So the additional information is really for anything pertinent to the I-9 that you think somebody who's reviewing the I-9 might need to know based on how the I-9 was completed or any copies of documentation that are provided. The section below, the certification section, the thing that I see most often left off of there is that employee's first date of employment. In this section, or in this example, the first day of employment is January 22nd of 2017. You have to make sure that that date matches the date that the employee has indicated on the front page in the employee attestation section, because if those dates are off, there needs to be a significant reason as to why. And I cannot think of very many reasons as to why. The other thing that I find happens with employers is that they get lazy. And that section down below, starting with number 4, I will oftentimes see that an employer will sign it and they will date it, but they will leave out their title. They will leave out writing out their name, the company's name, the employer's address. If you are hiring lots of people at the same time and go through orientation with a lot of people at the same time, you may want to consider pre-populating that information into a standard I-9 form that you just print off, so that all you have to do is sign and date, or maybe even just put in the person's name. But every single one of those boxes needs to be completed in order for the I-9 to be completed properly. So this just kind of goes over some of the things that I was just talking about, and I will be sharing the presentation with everyone who is in attendance, so that you have this just at your disposal to reference later. One of the things with regards to document numbers, there are so many different types of documents that can be utilized for work authorization, and many of those documents have multiple numbers on them. I can think of a couple of different states whose driver's licenses have a driver's license number, and then they also have some weird number down at the bottom, and it's hard to tell which is supposed to be included on the I-9. It's the employer's responsibility to figure that out. And so if you are ever unsure about a document number, you can go out to the dub.uscis.gov website, and you can look it up, as it will clearly let you know which document number to include. All right, and this is just something that I went over as we were reviewing it as well. When the employer does their review, they have to make sure that they enter information in every single area that's requested, and they can leave no blanks. So again, that tip, if you complete a large number of I-9s, consider creating a template of the Form I-9 that has that information already pre-populated. Section 3 is a form that gets utilized whenever you have re-verification or rehires. So this section, section 3, is at the bottom of page 2 of the I-9. It is used when an employee is rehired within 3 years from the date their Form I-9 was previously completed. So if the employee is rehired and their work authorization documents are the same as indicated on their original I-9 form, then all you have to do is enter in the employee's rehire date. If they had a name change, would likely change the work authorization documents. But if the information is just the same, then you will sign and date the form just indicating that rehire date. If their employee authorization on the previous form expired, then what you need to do is re-verify their employment authorization in section 3, provide the rehire date, and sign and date the form. The thing to keep in mind is that if their original form is not the current version of Form I-9, then you need to complete the section 3 that is on the current version. And that current version, the date at the bottom, shows that it's July 17th of 2017 with an N next to that date. So make sure that you're utilizing that as your most current copy of Form I-9. Any employees that are rehired after 3 years from the original completion of their Form I-9 do need to complete a brand new I-9 form. With regards to retention of I-9s, it has to be retained on all employees for a period of 3 years from their date of hire or 1 year after termination of employment, whichever is later. So all of your active employees should have an I-9 form. All employees who have been employed with you for longer than 3 years, once they terminate, you need to retain that document for an additional year, okay? It is really important that you keep I-9s filed separately from all other employee data. My recommendation is to either have a folder that is alphabetized so that you can find I-9s quickly by last name or first name, however you want to alphabetize, or maintain them in a binder. For a lot of my clients, I will create a binder that is alphabetized, and I will have sheet protectors, and every employee's I-9 and copies of their documentation go into one sheet protector. So every employee has a separate record. Current I-9s should be kept separate from terminated I-9s. And with terminated I-9s, you want to go through those as regularly as you can to pull out any that you can dispose of. So again, if the person was employed with you for longer than 3 years, they've been termed for a year, get rid of that I-9. And the reason I say get rid of it is you are no longer responsible for the data on it if it goes beyond that document retention time. So if there are mistakes that have been made on I-9s, once they hit that spot where they've been terminated and they're gone, you can get rid of the I-9. If somebody only worked for you for a period of 1 year, you have to maintain that termed I-9 for a period of up to 3 years from their original date of hire. So if they were hired on January 1st of 2017 and they left January 1st of 2018, you have to retain that document until January 1st of 2020. Because 2020 is the 3-year mark from when they originally completed the I-9, okay? You can store I-9s electronically or in paper form. You just need to make sure that they are in a secure location and that only individuals who should have access to them actually have access to them. And those individuals would include somebody who handles the HR role for the organization, just because work authorization can be a touchy subject, and also could put you into discriminatory hiring practices if you're letting other people see what people's work authorization is. You must file things so that you can present the form within 3 days of an inspection request from DHS, the Department of Justice's Civil Rights Division, Immigrant and Employee Rights Section, or the U.S. Department of Labor officers. So keep them organized so that you can produce them within 3 days if you do receive a notice of inspection. We're going to talk about EVerify because that is something that can really help employers out if it's something that they so choose. But before we talk about it, I want to know how many of you actually utilize EVerify for your Form I-9 verification. Okay. All right, so it does look like there is a nice group of individuals who are using EVerify. I personally have not used EVerify. So when I did this portion, I talked with a number of my colleagues who have utilized EVerify and learned a thing or two. So I'm just going to share with you what I learned. Basically, EVerify is a free internet tool that's available in all 50 states and beyond, so Puerto Rico, those kinds of places, that allows employers to quickly verify whether a new employee is authorized to work in the country. What it does is it cross-checks information from the I-9 form against records that the USCIS has and the Social Security Administration has. And employers can enroll for free at this website, www.uscis.gov/e-verify. If you use EVerify, you have to use it for all new hires, whether they are United States citizens or they are non-citizens. It cannot be used to pre-screen applicants for employment and determine their work authorization status. And you cannot terminate or take other adverse action against an employee based on a tentative non-confirmation, which we'll talk about here in a second. So it is used in lieu of just maintaining records. What EVerify does is it allows you to take the information that's completed on the I-9, enter it into the EVerify system, and get a confirmation back that yes, this individual is authorized to work in the US. So with EVerify, employees still do complete Section 1 of the Form I-9. And if you have an HRIS system that does all of your employment-related documents, you likely have an online I-9 form that they fill out. They will still fill that out. If you still do paper copies, you'll have them fill out the paper copy, and then you'll manually enter the information in. Employers still complete Section 2 of the Form I-9 and verify documentation. So remember, the employee fills out Section 1 either prior to their first day of employment or on their first day of employment. They bring their documentation in. They have up to 72 hours to bring that documentation in. My advice is to just get it taken care of that first day. You still are going to document what it is that they brought. So you'll fill out that Section 2 of the I-9 form. And if an employee chooses to use a List B and List C document, you have to make sure the List B document has a photograph, because EVerify will not accept anything that doesn't have a photograph. Once you've completed that form, you create a case in EVerify that will include the sections from Section 1 and Section 2. And then EVerify will provide a response back regarding their work authorization by either confirming, yes, they are authorized to work in the United States, or they will send you a tentative non-confirmation. And that tentative non-confirmation means that you have to get in touch with the employee, because the employee now has to follow up with the appropriate agency. And the tentative non-confirmation will tell you who they have to follow up with, whether that's the DHS or the Social Security Administration. Many times that tentative confirmation comes back, or tentative non-confirmation comes back, because the information has not been entered correctly. So my recommendation is to make sure that if you're utilizing EVerify or you want to use it, that you pay special care when you are entering the information into the system. Because if you transpose numbers or letters, misspell someone's name, do anything that's a typo, it will come back as a tentative non-confirmation. So just be really, really careful with that. So EVerify is required by contractors with federal contracts that contain a federal acquisition regulation EVerify clause in the contract. So they have to use EVerify for their new hires and for all employees, existing employees and new employees that are assigned to the contract that has that clause in it, which was issued after September 8th of 2009. So if you are a federal contractor, you will want to make sure that you take a look at the contracts that you have and see if they have that EVerify clause in there. And if they do, you need to make sure that you are now utilizing EVerify for your I-9 confirmations. There are also several states that have passed legislation requiring some or all employers to use EVerify. And as you can see, it's quite a list. And there are a couple of those that actually require it of all employers. And I believe Arizona and Georgia are two of the states that do require it. So just, my best recommendation would be to look in the states where you operate. Some states actually prohibit requiring employers to use EVerify. Other states allow it. So you will need to kind of make some decisions with regards to your own practices as to whether or not you use it based on that information. If you operate in multiple locations where one state requires it and another state prohibits it, and I'm going to use Arizona and California as my examples, because I did see that California cannot require private employers to use EVerify, but Arizona does have some requirements. Then you may have to have two separate operations with how you acquire that data, and you just have to keep both of those straight. There is a heads up that I wanted to give to those of you who utilize EVerify. January 2nd of 2020, so coming up here in just a few weeks, believe it or not, the USCIS will dispose of all EVerify records that are more than 10 years old, which are those that are dated on or before December 31st, 2009. So if you have been a longtime EVerify user, you want to make sure that you go in to the historic records report and download the information on employees that you might have done an e-verification on. So there's a lot more information that you can find on the EVerify website, but I just wanted to give you that heads up in case you had not heard. All right, we're going to talk quickly about some special circumstances. These are things that come up quite often, or at least often enough that they listed them in the handbook. And again, I want to reiterate that I am not an expert in I-9s when it comes to the special circumstances stuff. The handbook that the DOL provides is a 65-page document, and these special circumstances take up quite a few of those pages, but I'm going to hit on just the highlights of them so that you have an understanding of what happens in a situation when an employee brings a receipt for a driver's license instead of the actual driver's license, or how to handle employing minors, because this is a federally required form, and therefore minors should not be completing that type of a document. What to do if you have employees with disabilities who are unable to complete the I-9 on their own. How to handle future expiration dates, what to do with regards to evidence of status for certain categories like H-1B visas, how to handle name or identity information changes, and what to do in a situation where your organization merges with another. So to start off with, accepting a receipt in lieu of a list A, B, and or C item. When somebody brings a receipt in for their verification of employment, you are actually going to enter the word receipt and then the document title. So if they're bringing a receipt for their driver's license, you're going to write receipt dash driver's license. And then if there's some information that is provided on that receipt relative to the driver's license number or expiration date, you'll put that info in. When they bring in the original document, then you are going to cross through the word receipt and any other information that needs to be updated now that you have that original, and write that original information, then date and initial the correction, okay? If it's a document that, as you can see on here, we have that first one, a receipt for a replacement of a lost, stolen, or damaged document, they have 90 days to get you the original document. And you may forget all about that. So my recommendation is to set a calendar reminder for yourself so that you can obtain the actual document from the employee prior to that deadline, because once that deadline hits on that 91st day, you are no longer in compliance with regards to how you had that I-9 form filled out. And you cannot accept a receipt for a document if their employment is scheduled to last less than 3 business days. So if you're hiring somebody on a temporary basis to work on a project for 3 days, they have to have original documentation. You cannot accept a receipt. Employing minors, which are considered to be individuals under the age of 18, what you need to do there is to have the minor employee's parent or legal guardian complete section 1, and then on the signature line, they need to put individual under age 18. And then they will complete that preparer and or translator certification section. So let's say you have an intern who's 17 years old and they're going to work for you over the summer. Their parent needs to complete section 1. They need to indicate individual under age 18 in that signature and the date that they are filling that out, which should be the first day of employment, or at least prior to the first day of employment. And then they will fill out their information in the section for the translator or preparer. What the employer needs to do then is the minor employee, if they're unable to provide a List B document, let's say they don't have a driver's license, then that's fine. You just put individual under age 18 for the document title, but they do have to provide a List C item. So again, there's that whole list of items that they can bring from List C. They do have to provide a List C item. The same thing applies when you are employing individuals who have disabilities, which are a physical or mental impairment that substantially limits one or more of their major life activities, and who are placed in jobs by a nonprofit organization, association, or as part of a rehabilitation program. I'm going to use an example of someone that we had in our Minneapolis office. We hired individuals through a nonprofit organization that worked with folks who have different types of disabilities. And one individual had Down syndrome. And she was fantastic at interacting with our staff. She stocked all of our copy machines. She ran the postage meter. She sorted mail. She did all kinds of different clerical administrative tasks. And because of her disability, she was not able to fill the paperwork out herself. So the nonprofit organization filled out the documentation. They indicated special placement in signature of employee, and then they filled out the preparer translator section, right? The employer put special placement on List B because she did not have a List B item, but she did have in her situation, she had a birth certificate. And so we were able to enter the birth certificate information. And that is all that's required if you have individuals that you are employing who have disabilities that affect or substantially limit one or more major life activities. Documents that have future expiration dates. You will get some documentation that has a future expiration date. And a lot of times it will be for individuals who have permanent employment authorization. And that includes lawful permanent residents, asylees, and refugees. And with that existence of a future expiration date, it does not preclude continuous employment authorization. So it doesn't prevent them from continuing employment. It doesn't mean that subsequent employment authorization will not be granted, and it absolutely should not be considered in determining whether the individual is qualified for a particular position. So just because someone has a future expiration date on a work authorization document, you are worried about just getting the information taken care of at the time you fill out the I-9. You can certainly put on your calendar when that document might expire, if it's for someone who is not a U.S. citizen, who is not a lawful permanent resident, asylee, or refugee. And you can follow up with them if their documentation is going to expire, but you cannot utilize that as a reason for not pursuing them for a position. The evidence of status for certain categories. This gets back to the one that I was just looking at. Employees must be allowed to choose which documents that they will present from the list of acceptable documents, and do not over-verify by requiring or entering and or making copies of too many forms of acceptable documentation. Review, enter, and make copies of one List A item or a List B and a List C item. So if somebody comes to you with a lawful permanent resident card, and they happen to give you a driver's license and a social security card, and they are wanting to utilize that lawful permanent resident card, which is a List A item, you should not record the List B and the List C items and make copies of it in addition to the lawful permanent resident card. All right, make sure that you don't over document, because that's almost a heftier penalty, because the government may believe that you are discriminating against individuals based on a certain ethnic background or national origin. So just be really, really careful with that. So here are some of the certain categories. We have the lawful permanent residents. They can utilize a permanent resident card as a List A document, or as I mentioned, they can choose to use a List B and a List C document. Native Americans may utilize a Native American tribal document to establish both identity and employment authorization, but if their document does not contain a picture, they have to provide a List B item for documentation purposes. And with that, these are for Native American tribes that are recognized by the United States. And for a list of those, you can refer back to the DOL website for the Form I-9. Refugees and asylees should indicate alien authorized to work in Section 1 and enter not applicable as the expiration date, because those do not expire. And then we oftentimes have exchange visitors and students. We have folks who are here on a J1 visa. That means that they're in the US for a specific period of time to participate in a particular program or activity. An F1 and M1 visitor is a non-immigrant foreign student pursuing academic studies and/or language training, and they may get OPT, which is practical training experience that's directly related to their F1 visa. You can employ those individuals and utilize the documentation that they have. H-1B is a specialty occupation visa, and that is temporary employment for foreign workers in specialty occupations. That's typically in science, engineering, or computer programming. They have to complete the Form I-129 petition for a non-immigrant worker, and that has to be submitted to the USCIS, and the employee must meet established requirements. An H-1B visa can be extended for up to 3 years, and an H-1B visa recipient, the employee, can port their visa if they change employer. So if one employer wants to take over that H-1B visa, they can, but that has to be worked out between the employers. And all of these, it is up to the employee to make sure that they are maintaining their visa statuses. It's your responsibility to track when somebody may need to renew their visa, but it's their responsibility to actually go out there and get it and provide you the documentation that they have obtained it. And if they are unable to obtain a continuation of their work visa, they need to be terminated from employment. They have to have current work authorization in order to stay employed. Name or identity information changes. If somebody has a legal name change, they will complete Section 3 of the Form I-9, or actually the employer will complete Section 3 of the Form I-9. You will retain information regarding the reason for the name change. So if they were married, then you can indicate, if they sent you an email, or you can document somewhere that they were married. But you want to verify the documentation of a legal change of name and attach copies of all that information and documentation if it's part of your standard process. So if you maintain copies of documentation, you will want to maintain a copy of a marriage license showing that a name changed. You'll want to you'll make a copy of the driver's license record, just so that you have the new name on it, and then you'll fill out Section 3, which is that recertification or name change section. They had some information in here that I thought was really, really interesting and wanted to share it. It was about false identity correction. And if somebody has a false identity, they have to complete a new Form I-9 and attach it to the previously completed Form I-9 with a written explanation. And the example was that an employee may have obtained a work authorized immigration status in their true identity, and they now wish to regularize their employment record, meaning perhaps they used a false identity earlier. Now they have proper work authorization, and they want to complete the form in their real name. And if that happens, you are not required to terminate their employment. I just thought that was really interesting, so thought that I would share that with y'all. This one is one that comes up a lot, corporate mergers. Let's say you are an organization that acquires other companies, And if that is the case, you have two options with regards to the I-9 forms for the employees in the company that you are acquiring. You can either treat all of them as new hires with your company and complete a new Form I-9, requiring them to submit documentation, and you have to complete the new I-9 forms. Or you can take over the existing I-9s that they complete, or the previous I-9s that they had completed, treat them as though they are employees continuing their employment. But the thing to keep in mind is that you are responsible and liable for any errors on the I-9 forms of the employees that you acquire. So I know in a lot of circumstances, companies want to just make sure that all the T's are crossed and I's are dotted, so they will go ahead and issue all new I-9s, but you have both of those options. So regardless of which option you choose, if you are going to go with option number 2, I do highly recommend having someone audit all of the I-9s of the employees in the company that you are going to acquire, just to make sure that everything looks accurate and you can make corrections if corrections need to be made. So with regards to correcting the I-9, I am just curious if anyone out there has conducted an internal audit of their I-9 forms and made corrections before. Oh, great. Well, it looks like some of you have performed I-9 audits and have made corrections, so that's great. Those of you who have not, I do recommend that at some point you do audit your I-9s just to make sure that they are filled out correctly. And I realize we are now at the ending time of our session. I do have a few more slides just about correcting the I-9 forms and avoiding discrimination in your I-9 process. If you're able to stay on, great. If you're not, I do understand. And I'll try and get through this as fast as possible. So with regards to correcting Form I-9, here are the basics. As an organization, you can correct your I-9 form errors that you find in your own audit or through an audit that like someone like myself might come in and do, okay? And making those corrections demonstrates a good faith effort on the part of the employer to get the Form I-9 into compliance. And doing so may mitigate or lessen any penalties or fees that you might incur if you are audited by ICE. Any corrections that you make to an I-9 form must be done by drawing a line through the incorrect information, entering the correct information, and then initialing and dating that correction so that it is obvious what has been corrected. Section 1 corrections must be made by the employee. I can tell you that it's usually about 10% or less of corrections that I find when I do an audit that have to be made by the employee, but it's super simple to do it. If you audit your I-9s and you see that out of 100, these 7 require an employee to come in, you shoot the employee an email, you let them know that, hey, we just did an I-9 audit. We found that the I-9 was not completed correctly on the first day. What we need for you to do is to stop by the HR office or by the general manager's office or whoever's office, bring your documentation, or we just need you to stop by and sign and date your form, or we need for you to stop by and indicate what your work authorization status is. And let them know it's not nothing to stress out about. We just are trying to get our documents corrected. Section 2 and Section 3 corrections have to be made by the employer. And if you have an I-9 that really just had a lot of errors on it, you can redo an entire section on a new Form I-9 and then attach it to the original. So sometimes that's easier and a little less messy, and definitely is acceptable. What you want to do is any forms that you make a correction to, you want to put a note regarding the corrections in with the Form I-9 file, okay? We just had a question, if an employee changes a name, is it required to complete the re-verify section? It's not required. I will tell you, it sure makes it a little bit easier when you are auditing files if you have employees correct names on their I-9 form, because you should not be writing notes on the Form I-9. Like if Mary Jones gets married and she's now Mary Smith, writing Mary Smith at the top of her I-9 or even putting a Post-it note that has Mary Smith on it doesn't doesn't bode as well as having Mary Smith come in, and if she's made the name change, just changing it in that section 3, but you're not required to in all circumstances. Want to talk quickly about unlawful discrimination and penalties. So discriminating in the Form I-9 and EVerify verification process can violate federal law. So employers should not have different rules or requirements for individuals based on their national origin, citizenship, or immigration status. They should not request to see an employment eligibility verification document before hire just because somebody looks or sounds foreign or because they state that they are not a U.S. citizen. They should not refuse to accept a document or hire someone because a document has a future expiration date. If someone is legally authorized to work in the United States and you have extended an offer to them, if they're able to provide you with that documentation that says they're legally authorized, you have to pursue that. You have to hire them, let them fill out the I-9 form and get into your employ. Employers cannot or should not request specific documents from individuals, run an EVerify case, or based on an EVerify tentative non-confirmation. So if you are doing EVerify, you can't just request that they send you certain documents because it's easier for the e-verification process. You have to let them provide you with the documentation they want to provide, so long as one of those documents has a photo ID. An employer also should not request that an individual run a self-check case and or present documents showing that they cleared the self-check. So an employee can actually go in and do a self-check to make sure that their documents are going to clear, but you as an employer cannot ask them to do that. Employers also should not request that an employee who presented an unexpired permanent resident card present a new one when the permanent resident card expires, right? Permanent resident cards, they're permanent residents. It is no different than a driver's license or a passport. Once you accept one of those documents as documentation for work authorization, we certainly don't go back and ask everybody who has an expired passport now to redo their I-9 form. So we will not be asking permanent residents to do the same. Employers also should not request that during re-verification that they present a new unexpired employment authorization document if they presented one during their initial verification, right? So again, if they're within that 3-day window or that 3-year window for re-verification, they need to be able to choose any document that they want from List A or List C to go along with that List B document. We also should not limit jobs to U.S. citizens unless U.S. citizenship is required for the specific position by law, by regulation, by executive order, or by federal, state, or local government contracts. So you can't say that, oh no, we only want U.S. citizens in this job unless it is required by law. There are penalties for those prohibited practices. So DHS or an administrative law judge can impose some significant penalties if an investigation reveals that an employer knowingly hired or knowingly continued to employ somebody who is unauthorized to work in the United States. Okay, and employers can be subject to fines for each offense that they find. So if somebody has hired a dozen individuals who do not have work authorization in the United States, they will be penalized 12 times for hiring somebody, because if it's proven that they knew that they should not hire that individual, or if they continue to employ them even after they knew they should not have hired them. Second, if an employer fails to properly complete, retain, and or make the Form I-9 available for inspection, there are monetary penalties for each violation of that. So if your I-9 forms are completed incorrectly and you have 20 of them that are completed incorrectly, you will be fined for each of those 20 forms. It's not just you're fined once because you completed it incorrectly. Employers who are convicted of having engaged in a pattern or practice of knowingly hiring unauthorized aliens or continuing to employ aliens knowing they are or have become unauthorized to work face fines and or 6 months of imprisonment. That's a pretty serious offense. And persons who use fraudulent identification or employment authorization documents or documents that were lawfully issued to another person, or who make false statements or attestation to satisfy employment eligibility requirements, they can be fined or imprisoned for up to 5 years or both. And that applies to the employees who are completing the I-9 form. So it's a pretty serious matter. And the thing to keep in mind, we're going to do this polling question. To avoid discrimination in the verification process, employers should not refuse to hire someone because of a document that has a future expiration date. Is that true or false? It is true, and I apologize, it's a triple negative. So if an employer wants to avoid discrimination, they are not going to refuse to hire somebody because they have a document that has a future expiration date, okay? They will hire that person even if they have a document that has a future expiration date. Maybe that's a better way of saying it. Right, so in summary, it's an employee's responsibility to provide their appropriate documentation to confirm that they're legally authorized to work in the United States. It's an employer's responsibility to verify and document that legal authorization for all of the employees that work for them. Employers should follow the proper steps to complete and retain the form correctly and do it in a timely manner. Again, employee must fill their form out before or on the first day of hire. If they do it before, it has to be after they have accepted the job offer. Employers have to verify the documentation within 3 days, which means the employee must bring that documentation in within 3 days. If they do not, you need to terminate them or at least put them on some sort of suspension so that they are not being paid, they are not coming back to work until they bring that documentation. And if an employer is concerned with their organization's Form I-9 processing or the documentation, they really should conduct an audit or have someone else come in and conduct an audit to help them figure out what corrections need to be made. All right. If you make a good faith effort to comply, as I mentioned earlier, it will mitigate risk. And that's really what the government is looking for. They want to make sure that employers are doing what they can to hire individuals who are authorized to work in the US. All right, that is it. And I do apologize that we went over. Because of that, you know, if there are a couple of quick, easy questions, I'm happy to answer those. Otherwise, we'll gather the questions and I will send out answers to those questions when I forward the presentation to everyone.
Hey, Lori, the ones in the chat box,
Okay.
I know were you able to answer any of those?
I've been trying to.
Okay, because I can get the rest through a report and we can answer those offline.
Okay, I did see one that said, is it a bad practice to have a new I-9 even if it's within 3 years? No, it's not a bad practice, but you don't have to go through that. And what it might do is it may cause someone who has difficulty providing their work authorization documents. You know, if it's not something as simple as a passport or a driver's license and a social security card, if it's some other form of identification that's a little more difficult, it may look like you're discriminating against an individual based on, you know, ethnic background, national origin, that kind of thing. But it's not, I wouldn't say that they're going to look at you and say that you're doing something wrong, but you may want to follow the process where you don't have to complete a new form. I think I answered the next one about EVerify, but I'll make sure that I put that in writing. Oh boy, this is a great question. They hire 95% of their employees remotely. If they have a name change, what's the best way to get the form updated? I will need to do some research on that. I'll have to look into that. And there was someone who asked, do you need to have an I-9 for employees hired before 1986? I don't believe it's a requirement, but I want to look into that a little bit further because I just haven't seen it very much. I know that I had one client who did have employees who were hired prior to that. They did not have I-9 forms on some of them, but they had them on others, which was kind of odd. So I want to look into that. Okay, it looks like there's a whole lot of questions. So if you guys want to just put the questions out there, like I said, I will do the research I need to find the answers for you, and we'll get that out to everyone.
Thank you all so much. We do have copies of your questions, so we will get that out, and we hope you have a wonderful day.